Mom has died, dad has died, some loved one has passed away, and now you're trying to figure out, where do you start? Maybe the loved one left a house or a life insurance policy or a bank account, and you know there's an asset there, and you just don't know how to go and get it. One of the most common questions I get in my office is just a very general question of, what do I do now? Mom has died, dad has died, some loved one has passed away, and now you're trying to figure out, where do you start? Maybe the loved one left a house or a life insurance policy or a bank account, and you know there's an asset there, and you just don't know how to go and get it. The first thing you have to know is, the place where you go after a loved one has passed away is called the surrogate court or the probate court. The surrogate court or the probate court will be located in the county your loved one lived in when they died. And you would make an application to be either the executor or the administrator of your loved one's estate. If you don't know where the location of the surrogate court is in your county, then just Google it. You can type in the word surrogate court, county that your loved one lived in, and all of the information will come up: address, telephone number, and then you can give them a call. Many surrogate courts do allow you to walk in now. You don't have to make an appointment, but some still request an appointment. So I would recommend giving them a call and seeing what their procedure is. Now, there are some things that will factor into how the surrogate court will process your request, and things like that include the value of the assets, what your relationship to the person who passed away is, things like that. The most common scenario is the loved one passed away and left a house. So if your loved one passed away and left the house, you would go to the surrogate or the probate court, and you would take with you the original death certificate and your identification. And if the person who died had a will, you would take the will. If you're making an application to be appointed as the administrator, you'll also need to bring some documentation evidencing the assets that your loved one has. So, for example, if your loved one owns a house, then you should bring proof of the copy of the deed with your loved one's name on it, or tax records or something showing that your loved one owns real property in the county. Or if it's a bank account, you can bring the bank account statements. You'll have to be able to establish that your loved one's estate is over a certain threshold value wise, so the surrogate will know how to process your application. Now, the surrogate court and the probate court, they are going to want the original will. You can probate a copy of a will, but not usually through the surrogate court. You'd have to go through the superior court. That would require more steps. It's a little more involved, and you may need to contact an attorney for that. But if you have the original will, and if your original will has all the original signatures, all of the pages, you can submit that, take that, your original death certificate and your identification, and go to the surrogate court and file to be the executor of the estate, assuming you're named in the will as the executor. So if the will doesn't name you as the executor, then the person who is named as the executor is the person who submits the will. Now, if there is a reason why that person can't serve as the executor, then you can take that up with the surrogate, and there are ways to make application, but you would not be making an application to be an executor. You would then be making an application to be an administrator. An administrator is the title that's given to a person who wants to have the authority to settle their loved one's estate, but there was no will, or they're not the person that was selected in the will. The steps that I am giving you now is for times when no one's fighting over who should be the administrator or who should be the executor. Because if more than one person is eligible to be the administrator, or there's an issue with the person who's selected to be the executor, and there's a contest on that issue, then you have to go to the superior court. But very simply, your first step is always to the surrogate court in the probate court. So after you have submitted your paperwork to the surrogate court, They will give you the papers that you have to sign to qualify you as the executor, qualify you as the administrator. And once you sign those papers, you get back what's called a testamentary letters or letters of administration. These are the official documents that give you the authority to now go out into the world and represent, take authority over the assets of your loved one. Just because you're named in the will as the executor, that's not where the authority comes from. You still have to go to the surrogate court. You still have to fill out the papers. You still have to submit the will and get approval and have the surrogate court issue you those testamentary letters. They're called testamentary letters if you're an executor with a will, and they're called letters of administration if you are there is no will, but you've gotten the same authority to oversee the collection of the assets and things like that.